Welcome, thanks for joining me. I'm attorney David M. Chester from the Chester Law Group, an Ohio personal injury law firm. Today we're here to discuss what is a deposition. A deposition is a process where parties to a lawsuit in court ask each other oral questions under oath. A court reporter is present and they type up what is said. Sometimes the deposition is even videotaped. The types of questions depend on the types of the case. These questions ask basic things such as where do you live, if it's an accident case, were you hurt, were you treated, where did you treat, how long, how much did it cost, have you been hurt before, when and where have you been hurt before, and have you been treated before for similar injuries to the same body part that you claim is hurt in this accident. Now, in contrast, questions to the defendant in a car accident case, for example, would be, was he drinking, has he been convicted of drunk driving, has he been convicted of any other felonies, does he take medication that would impair his driving, does he wear glasses, was he wearing glasses, does he have prior traffic accidents or tickets? You get it. Both parties are trying to get information they can use at trial to their advantage. They want the information that makes the other side look bad or proves their version of the facts are the right one. In a car accident case, the plaintiff wants to know if the defendant has a history of causing car accidents, while the defendant, differently, wants to show that the plaintiff had prior injuries or wasn't hurt in the accident or over-treated for the accident. Attorneys for both parties can object to any question at the deposition they feel is improper, and if there is a real issue, the court gets involved in the discovery issue. Many times your attorney will object to a question in a deposition but tell you to answer anyways, and then later on they'll argue with the judge to determine what the jury hears, if anything. If the deposition turns nasty, your lawyer may file what is called a motion for a protective order to stop the other side from asking certain questions or asking for certain documents. Now, if you are served notice for a deposition, your lawyer is going to tell you you have to attend. It's not optional.